Hi, everyone. Thanks for being so patient. We're dealing with some technical difficulties trying to get everybody on. So we'll just go ahead and get started while we try to get those worked out. So thanks for taking time out of your days to be here. My name's Ashley Koirtyohann. I'm a shareholder here at RMWBH. We're here today to talk to you about the importance of a solid pool contract as we kind of ramp up for the summer season. And I'm fortunate enough today to be joined by Kevin Kimmel with Brady, Chapman, Holland Associates. If you want to introduce yourself, Kevin.
Howdy, everybody. Kevin Kimmel, Brady, Chapman, Holland Associates, and Tim Brady is going to be joining us as well.
Yes. So they're kind of here to talk about the insurance side of things, because really at the end of the day, you really need your pool MSA and your insurance, to kind of talk to each other and work together to get the full benefit of either. So we'll just go ahead and get started. Of course, this wouldn't be an attorney presentation without a disclaimer. So our presentation today is based on the law today. As a lot of you probably know, the law affecting property owners associations changes at least every couple of years, as the legislature adopts new statutes, but also as case law develops and things like that. So everything we say today is based on the information we have available today. So if you need specific legal advice about your association, you should be discussing that with your association's attorney. We're just kind of going to go over some general information. The agenda for today is, I'm going to talk to you all a little bit about the contract that governs the relationship between your association and your pool contractor, the important things to look for, sort of risk management provisions and indemnity. And then I'm going to pass things off to Kevin and Tim to talk about coupling that contract with adequate insurance and sort of the importance of knowing what you're looking at when you're looking at the insurance that a contractor has available. So to get started, the summer season is still a couple of months away, but a lot of y'all are probably looking at your pool contracts now, trying to get those in place before the summer season rolls around. It's really important to make sure that you have a solid contract in place. And, the language we're going to use throughout this presentation is a MSA, or a Master Services Agreement. For those of you who are unfamiliar with that terminology, it's really just a contract that kind of governs an ongoing service relationship between, in this case, the association and the pool contractor, as opposed to something like a construction contract, which is only, for a one-time project. So this is an ongoing service agreement. And you might be wondering, why can't we just sign, the agreement that the pool contractor provides? And the first thing is that, as is to be expected, when they're preparing their form, they're drafting it in a way that benefits them. They have themselves in mind, which is fair. And it's often going to either be missing a lot of the terms that we're going to discuss today completely, or it'll draft them in a way that's not as comprehensive as we like, or maybe the indemnity goes the opposite direction of what we'd like. So really, the contractor's agreement can provide a really helpful scope of work. It can provide a lot of information that can be used to define the sort of day-to-day terms. So what services are going to be provided, how much is it going to cost, what are the payment terms, things like that. But, the preference is that you provide that to the association's attorney, and they're probably going to want to supplement that with some of the things that we're discussing today to make sure that the association is able to sort of manage the risk in the event that something bad happens, like an injury or a death. So you do want to make sure that you're going over those in depth, ideally with your association's attorney, to make sure that you're protected as much as you can be. And okay, so one of the things, some of our clients will come to us and they'll ask us to prepare an agreement to be used in like a request for proposals. So, we'll do the initial draft. We don't know the contractor that's going to be selected. We don't know what that contractor's insurance looks like. So we're not really able to personalize it for the contractor. So we'll put in the insurance levels we'd like to see. So our initial draft might include some pretty high coverage amounts that we've developed by talking to brokers and other insurance professionals. And it might be that, those are sort of aspirational insurance amounts. What we've seen is that a lot of contractors are not able to obtain the amount of insurance that they used to be able to. So both in terms of the coverage amounts, but also that they're having to pay more money for less coverage than they used to. So, it's all well and good for us to say we'd love to see them carry $10-20 million of insurance, but a lot of contractors are not able to secure that because, as is the case with a lot of association side insurance, costs are just increasing, and the sort of amounts of coverages that are available might be decreasing. So one thing to think about is rather than just kind of accepting the insurance that the contractor has, might be to have them go out and talk to their broker and request sort of a quote for what it might be to increase the coverage to something the association might be more comfortable with, and then the association can decide if it's worth it to them to help the contractor cover that added expense. So, it might be that it might be cost prohibitive, but if you kind of go through that process of getting that bid, evaluating the cost, deciding if it's something that the association is willing to take on, you can kind of make an informed decision with all of the information available. So one of the most important things is to make sure that your contract is coupled with adequate insurance on the vendor side that will kind of support these obligations under the contract, like the indemnity obligation or these, sort of, if something bad happens, what's the pot of money that's available, and making sure they actually have access to that. So it's just some things to consider from the association side. First, some excess policies might not cover events that occur on certain pool amenities. So, they might exclude injuries that relate to slides or diving boards or diving rocks or beaches or these other sort of attractions. The reason they kind of exclude those from the coverage is that they're more likely to result in an injury, and they obviously don't want to increase their odds of having to pay out on a claim. So that's something to be aware of. If you have, a pool that includes these sort of amenities, just trying to figure out whether or not those are excluded. Also, a lot of these policies are not written on a per project basis, which means, if you have a pool contractor who is managing your association's pools, but they're also managing 20, 30, however many other pools, all of those associations have access to the same insurance. So, for example, if they carry $10 million worth of insurance and there's a catastrophic injury or a death at another property, it is possible that a claim that doesn't even relate to your association could sort of deplete the insurance that's available. So we just want to make sure that y'all understand that you might not, that, maybe $10 million worth of coverage doesn't necessarily mean that that's $10 million worth of coverage for your association specifically. And these are the sort of things that you really want to kind of lean on your broker to help you evaluate when you're looking at a vendor's insurance, because it might be that you can't always tell from looking at something like a certificate of insurance, or maybe you're not used to looking at them. They're not really, a lot of insurance documents are not written in a way that's, easily understood by people who aren't in the business of doing it every day. So this is a situation where you want to ask for a copy of the contractor's certificate of insurance, as well as the applicable risk transfer endorsements, and then pass those along to your association's broker to let you know what those mean and how they impact you, and whether it's worth trying to negotiate some sort of changes with the vendor. Additional insured status is a huge one. You want to make sure that you actually have access to the to the vendor's insurance, and it might be that you don't if you're not named as an additional insured. So they might have fantastic insurance, and if you can't, obtain the benefits of that coverage, then it doesn't really do you any good. So the way you do that, or one of the ways you do that, is you make sure that your association is listed as an additional insured on the policies. And it may be that if you're managed by a management company, you need to look at having the management company named as an additional insured as well. You want to confirm that this has happened before the contractor begins work, because, theoretically something could happen on day one, and you really want to make sure that that's in place before any sort of opportunity for a claim to arise occurs. And you also want to be sure that the association's full legal name is listed on the additional insured status. So I use the example here, Sample Homeowners Association, Inc. If that's your association's name, that's what the additional insured should be. It shouldn't be a shortened, abbreviated kind of casual version of it, Sample HOA, SHOA, things like that. And we see that a lot. And that you really want the full legal name so there's no confusion about who that's talking about. And kind of on a related note, the full legal name should be the name that's used on the contract itself. So the contracting party should be the association's full name. And if you're not sure what that full legal name is, or maybe y'all go by an abbreviation, you just want to check either your articles of incorporation or your certificate of formation, which is the document that's filed with the Secretary of State when your HOA is formed, when the entity is created. And so you want to double check that and make sure that you're using that proper full legal name, so there's no doubt about who the additional insured is or who the contracting party is. So I've included what I would consider to be some of the most important provisions for risk management here. And then also I added bullet point for scope of work, which is less about risk management, but also just an incredibly important detail of your contracts when you're looking at them. Indemnity we'll go into some more detail about in a couple of slides, but that is essentially the indemnity provision is going to be what governs, who's responsible for certain costs when a claim is brought against the parties to the contract. So the way, we would normally draft it for our clients, the pool contractor would be indemnifying the association, meaning that if there's a claim brought against the association that arises sort of out of the work being provided by the pool contractor, then the pool contractor would have to cover the cost of defense as well as any damages awarded against the association. The insurance provision, again, it's really important that the MSA and the insurance policies kind of talk to each other or work together. A lot of times you might not get the benefit of the contractor's insurance if the MSA doesn't actually require them to name the association as an additional insured, doesn't require them to carry certain insurance. So you really want to make sure that those work together and that the insurance provision is tailored to the insurance that that the vendor actually carries. But also that, if you're going to require certain insurance, following up to make sure that the insurance carried by the vendor complies with those requirements. Termination is another one that I see missing from a lot of contracts that were brought into, maybe we're not contacted until there's already a dispute. Termination is incredibly important to outline. Our preference would be just the option for either party to terminate upon written notice to the other party. A lot of vendors' agreements will have, sometimes a very onerous termination provision where you have to pay out an early termination fee. If there is going to be an early termination fee, your attorney might look at sort of carving out termination for cause. So, not having to pay the early termination fee if the termination is the result of, the contractor either not doing something they were supposed to do, doing something they weren't supposed to do, not doing the work to the association standards, failing to carry proper insurance, things like that. So you do want to make sure that you're, while you hope when you're entering into a contract with somebody that it's going to be a great relationship, you also have to prepare for the fact that things might go south. So, hope for the best, prepare for the worst. For lifeguards, specifically, including minimum training requirements that you want for the lifeguards who are going to be present on your property. A lot of lifeguards are very young, teenagers often, and just making sure that they've gone through things like CPR training can be incredibly beneficial. And then the scope of work, which again is not really, it's not so much of a risk management provision, which is really the focus of today's presentation, but I didn't want to not mention it. The scope of work should include everything that you're expecting the contractor to do. We see a lot of times where a scope of work is either vague or it's missing some of the detail, and the client will come to us and say, well, this contractor breached the contractor breached this contract because they're not doing XYZ. And then when we go to look at the written scope of work, that's not included. And it might be that you had a verbal discussion with them at some point where they said, well, this price includes all of these services. But if that doesn't end up in writing in the contract, it's very hard to argue that they've breached anything. So, taking the time to look through that scope of work before you sign the agreement to make sure it includes everything you're expecting to get for what you're paying the contractor is very important. Just as a reminder, Section 209.0052 of the Property Code requires that bids over $50,000 be solicited using a process adopted by the association. This applies to our single-family associations, not to condos, but you want to be sure that, and it might be that your pool contract is not $50,000 or more, but for some of our larger associations, that certainly is the case. Making sure that you have that bid solicitation policy in place, or some sort of bid solicitation process that's been adopted by the association, and making sure that you're complying with that. So usually that will lay out how many bids you're required to obtain, assuming that, the number, assuming you have people willing to submit bids, how the RFP process works, how those bids are going to be evaluated and awarded. An RFP can be a really great way to do this. So a request for proposal, that might be one where you come to your attorney, you say, hey, can you draft, what you would consider to be the ideal pool MSA? And then that document, while it's not finalized because we don't know details about the contract price or who the contractor is going to be, it will include all of these insurance requirements, all of these indemnification requirements. That can be provided to the potential bidders so that they understand what the association's asking for, and you really don't end up in a situation where you're having to argue over those provisions down the line. So that's a good option. Indemnity, as I mentioned, an incredibly important provision, highly technical. This is one where you definitely want your attorney involved, because not only do you want somebody looking at the actual language to make sure that it says what we want, but depending on what the indemnity says, there's actually requirements for things like font size and these sort of fair notice requirements to basically, those are created by case law. So basically the Supreme Court has said in certain circumstances, depending on the type of indemnity, it needs to be, a larger font than the surrounding text and things like that. So there are these like tiny different technical requirements that you want to make sure are complied with. So the questions when you're looking at an indemnity is like, who is accepting the risk related to the performance? It may be that the vendor's proposed contract kind of has the association indemnifying the vendor. We obviously, as the association's attorneys, prefer to see it going the other way. So you want to look at, who's indemnifying who. And sometimes these contracts will include these very vague mutual indemnities, which means that like nobody's really on the hook at the end of the day. So just making sure you understand who is the risk being transferred to. Considering, are you paying the vendor for that risk? And what I mean by that is it may be that you ask for a more thorough indemnity and the contractor comes back and says, well, we're willing to do that, but you are going to have to pay us more money because we're taking on more risk. Is the contractual indemnity requirement funded by insurance? So at the end of the day, most of these vendors are not going to have substantial assets that could be used to satisfy a judgment. So say the pool contractor agrees to indemnify the association, the costs of defense are a few $100,000, maybe damages get awarded. The indemnity is only as good as the insurance that backs it up, because it's very unlikely that without insurance, that indemnity is going to be covered by the pool contractor's assets. So just making sure that the indemnity is paired with insurance, and figuring out, if there's not sufficient insurance, what sort of non-exempt assets do they have? Texas is a very debtor-friendly state in terms of judgment collections. So most assets are not going to be able to be seized. That is something you can look at. Is there a duty to defend, and who has control of that defense? As you may be aware, a lot of claims are not valid. A lot of claims do not result in a judgment against the associations. Also, a lot of cases never go to trial. A lot of cases settle. So it may be that, you don't really need to worry as much about a judgment being rendered, but those costs of defense are going to be incurred anytime anybody files a lawsuit. So who has the duty to pay for those defense costs, but also who has control over that defense. So ideally, from the association's perspective, you'd want a situation where the contractor is required to cover those costs of defense, but the association still has some control over the defense itself. So the attorney that they use, or whether to accept settlement terms, or, you know, sort of what is going to be the strategy for the litigation, things like that. So just because the contractor is going to be covering those costs doesn't necessarily mean that the association will be willing to give up control over its own defense. And then you also want to know how third-party claims are going to be handled. Most claims that we see, at least arising from a pool agreement, are third-party claims. So a homeowner or, you know, their guest gets injured by the pool at the pool, and they sue everybody under the sun. They sue the pool contractor, they sue the association, they sue the management company. These third-party claims provisions of the indemnity will handle things like, for example, if the contractor is going to settle, making sure that any settlement by the contractor also includes a settlement of, or a release of, the claims presented against the indemnified parties, which would be the association and the management company in that case. You know, the required notice, how to put the indemnified parties on notice of a third-party claim, sort of all of these really address the processes. You know, what happens if a lawsuit is filed? You know, who's responsible for what? Who gets control over what? And these sort of just litigation management issues. And you want to make sure that those are addressed, because it's not inherently involved in every indemnity that we see, and we really think it's important to kind of call those issues out specifically. So I think now I'm going to pass it over to, it looks like we have Tim on, Tim and Kevin. So they're going to talk to you a little bit about insurance and how this all ties together.
Thank you, Ashley. Sorry for the issue getting in here. Kyle figured it out, so I appreciate it, Kyle. I took down some notes to kind of bridge this into the insurance side of it as you were talking. I think one of the best comments you had was hope for the best, but plan for the worst, because while maybe they're rare, when pool incidents do occur, they're usually not cheap. And if you slide back one and go back to the indemnity, I just want to clarify the difference in being an indemnity within a general liability policy of a vendor and being an additional insured, because it can be rather large. If our indemnification is broad enough to pick up a claim and have the contractor indemnify us, and their GL policy starts paying, and we spend $500,000 on defense, and we had $1 million policy, we now only have $500,000 to defend, versus additional insured, they pay for the defense cost outside the limit. So $1 million limit for that vendor, $500,000 in defense. We still have access as the additional insured, as the association, to the vendor's insurance policy. So indemnification and insurance really are the belt and suspenders of a vendor contract. And while we're talking specific to pool, I think it's important to point out that all vendor contracts are important from both sides, both indemnity and insurance. And so we can continue to talk through pool specific examples, but landscapers and security contractors and any of those fall right into the same. They sometimes have different exposures, but I just wanted to bridge that real quick. Also, why it's so important to mirror the indemnity parties to the insured parties and almost have that definition together. All the people that we want indemnified are also the same people that we want to have additional insured status for. Kevin?
Nothing to add on that piece.
Okay. All right, so we'll get into the types of insurance purchased and why, the amount of coverage, and the financial ability to defend those claims. Again, Ashley pointed out that most of the time our indemnity is funded by a properly executed insurance contract. So I'm going to hit on this probably every slide. A certificate of insurance from a vendor that lists you goes on to say you are an additional insured as long as it's required by a written and executed contract. And that's what we see missed a lot when big claims happen. And then one of the questions over there in the chat was, when a lawsuit occurs, what is the impact of future insurance costs for the association? It depends. With a good contract, probably no impact, because your insurance is not left holding the bag, the vendor's is. With a poorly written contract, the association's insurance often pays half of the entire claim, and the vendor and the association insurance companies pay dollar for dollar all the way up to the limits of insurance. So the properly executed contract keeps us away from that and keeps our insurance out of the line of fire, and therefore helps control our costs for years to come. Go ahead, Ashley. Kyle. Okay, so AM Best is the largest regarded financial rating institution for insurance companies. We want to see an AM Best rating of A, -7 or better in most instances. The A is that they're in excellent financial condition. The 7 behind it is just the size, the dollars they have in the bank to take care of your claims. Insurance limits has become a tough one because of capacity issues. Like Ashley alluded to, so many people are having trouble buying the 10, 20, 30, $50 million of insurance for a couple different reasons. One, I think claims frequency's up, severity's up too. You drive around Houston, Texas, or San Antonio or Dallas and see plaintiff attorneys billboards, and they want to go after insurance companies. It long term has a financial impact and drives insurance pricing up. And so I like pool vendors and landscapers to have as high limits as financially possible for the association to get out of their vendor. Ashley, I think you'd think that's a fair way to approach that too, right? If the cost is the same and you've got a vendor that has higher limits, I would lean that way.
Yeah, no, I agree.
Okay. Understanding depleting limits policies. So Ashley talked about the per project aggregate, often found in a general liability policy. That's not available to all. You have to ask for it. And why that's important is because the communities across Texas that your particular vendor might be servicing might have a claim that happens this year that you're not made aware of. And by the time your claim hits, there's no limits left for them to take care of you. Well, with the per project aggregate, your contract stands apart from any unrelated party's contract. So I hope that makes sense. From a per project aggregate, that's why it's so important. Okay, so the next couple slides kind of cut up a certificate of liability insurance and what you're looking at. On the right is the insurance companies. At the top is the disclaimers that this doesn't provide any coverage, and then it also goes into the additional insured provisions. Flip to the next one. This goes through the limits of the particular insurance companies that were shown on the last slide. At the bottom in the fine print there, it says general liability, additional insured, and then there's an asterisk. So if you go to the next slide, we see what those asterisks are about. I'm sorry, that's just a signature. One more. The asterisk says, highlighted here, when required by written contract signed by both parties prior to the loss. So the certificate, again, is just a piece of paper that says, hey, you have additional insured, where you're going to have defense outside the limits of liability as long as you have a written executed contract that asked for it. So not a written contract that asks for indemnity, it's a written contract that asks for additional insured specific to each one of those policies. So general liability, auto, excess liability are the three big ones. You got ahead of myself? Kevin,
That's
you
what I
want
was
to
trying
just
to
bring it home?
That's what I was. Yeah, that's what I was trying to get to. So
why
Tim
don't you cover it again?
So yeah, Tim already went through the per project piece. I'll touch on the aggregate. So on the certificate of insurance for general liability, for example, it shows typically the most common 1 million per occurrence, 2 million aggregate. So if you had an incident occur at the pool, you're looking at a maximum for the primary general liability if the limits are still available of 1 million per occurrence. However, if future claims occur, you still have occurrence limit left for any further claims that may happen. So let's say the first claim, if the policy ran from January 1st of 2024 to January 1st of 2025, full season starts May, end of May. So if a claim occurred in the first weekend, you have $1 million for the primary general liability policy. You then only have another $1 million left throughout the rest of the policy term. And then as we talked about excess liability, unlike the general liability, is going to be depleted as it's used. So if the vendor has 2 million in excess liability and a claim settles for $2 million, the general liability picks up 1 million. The excess liability would, for covered causes of loss, would pick up the next million. So they would be left with $1 million on their general liability and then only $1 million left on excess. Next slide. Types of insurance that, as Tim mentioned a little bit earlier, that we'd like for you to look at and consider and make sure your vendors have would include general liability, workers' compensation, which provides injury to their employees, the lifeguards that are watching over the pool, motor vehicle or auto liability insurance, umbrella excess. The employer's liability actually ties into workers' compensation. Pollution has become more popular. Recent litigation around Legionnaires cases involved with pools. So the standard general liability is going to include a pollution exclusion. So looking at environmental coverage or requiring your contractors to carry it and including some risk transfer there is something to consider as well. When a claim pays, whose insurance pays first? That goes into how the contract is specifically worded, which is extremely key. And I can tell you that our firm has reviewed hundreds of contracts, and probably one or two, as Ashley mentioned, were written in the benefit of the association. And so it's key to review those contracts and make sure it includes all of these specific individual insurance items and the insurance provisions, such as additional insured, waiver of subrogation, primary non-contributory, that would actually provide the risk transfer. If those aren't included, then again, as the certificate states, it has to be required by the written contract. So we need those included and outlined by every line of coverage in order to apply. Go ahead, Tim.
Let me go a little deeper on the auto. So it says motor vehicle here. A lot of our vendors will use personal vehicles in our communities. And so I think it's incredibly important to expand upon that and make sure that you're reviewing to make sure that they not only have owned autos of the vendor covered, but also the hired not owned exposure of their employees using their personal vehicles in the community.
Next slide. So before we get into questions, I also took a couple notes going through what Ashley talked about as well as Tim. And so a couple key pieces that we would recommend you take away. Certificates, again, are just a piece of paper. They are as good as the ink that is written on them. The contract is key. Whether, again, it's with pool contractors or any of your other vendors, work with your attorneys. A lot of the times when we're reviewing contracts and we request a copy of a pool vendor's contract as an example, we get that contract, but it's not signed by the actual pool vendor themselves. So making sure that the contract is executed by both parties and that is retained is also key. Because again, as that certificate showed, it wouldn't apply unless it's executed by both parties. Ashley mentioned one earlier. The full legal name of the contract should be what is used, articles of incorporation, certificate of formation. Same goes with your insurance policies. I can't tell you the number of times that when we get involved into new opportunities that the wrong legal name is used. If you have a large enough claim, carriers will look for ways to get out of potentially paying a claim. And if the name is wrong, that is one way for them to potentially deny a claim. Those are the key piece takeaways that we would recommend as far as working with your attorney and contractual risk transfer.
And I would just add real quick that, you know, a lot of these seem like over preparing for something that might never happen, but these catastrophic claims do come up. Our firm alone has handled a couple of drowning cases in the past few years, and the issues of insurance and indemnity do end up being an issue. So you do end up kind of having to go back to the contract and make the argument for why the vendor needs to indemnify the association, or why the policy should be providing a defense. So these are things that come up. You hope they never do, and for a lot of pools they won't. But it's certainly not outside of the realm of possibility that one of these claims will happen. So just making sure that you're preparing for those and putting the association in the best position it can be in the event that something like that does happen. I guess we can go through some of the questions. I saw one earlier. Does this apply to developer control for bids? So the bid solicitation provision of Chapter 209 does not include contracts entered into by the association during the development period. So you don't have to worry about the bid solicitation process if you're still under developer control. Another question about that, the law only applies to new contracts and not renewals. Arguably, yes, it would not, or I'm sorry, let me rephrase that. Arguably, it would not apply to a renewal. Usually renewals are governed by an existing contract, so you're not really entering into a new contract.
But I would add there, Ashley, that there's many times where we get a contract after it's already been signed, and we have been able, that if the vendor does have the proper insurance provisions, to go back and agree to them making a change, or if not, at renewal, making those changes.
Yes, absolutely. So a renewal is a good opportunity to make sure that the contract, maybe you signed a contract a year ago or 2 years ago. Renewal is a great opportunity to go back and look and see if it needs any sort of revisions. Also, in the event that you don't get an attorney or your broker involved before a contract is signed, usually there's some sort of provision addressing how to handle amendments to an existing contract. The ones that we draft would require that to be in writing, but it is certainly something that can be done if both parties can agree on an amendment. So it's not necessarily, the end of the world if you've signed an agreement already and you've forgotten to ask these questions. I would encourage you to still reach out to your attorney, or your association's attorney, or to the association's broker to figure out, hey, we already signed this, but I saw this presentation and I want to make sure everything's good, because we might be able to clean it up before a claim occurs.
Yeah, the typical contracts that we review will say will carry workers' compensation as required by law in the state of Texas. Well, workers' comp isn't required in the state of Texas.
Mhm.
So I would have them further clarify whether or not they're providing coverage for injuries to their employees. The other item we typically see in most contracts is they'll list they're carrying general liability or excess liability, but they don't include the true insurance provisions such as additional insured, waiver, subrogation, and primary non-contributory that you need in order for the risk transfer to apply. So be careful of those as far as the insurance requirement section.
We have a couple of questions about the presentation being available. I'm going to defer to Kyle on that. I'm not sure. Kyle, does this get, I know we have a YouTube channel that has a lot of our webinars on it.
Correct, Ashley. So yeah, in a couple of weeks, we'll get this posted up to YouTube, and the slides will be emailed out to all attendees.
Okay, perfect. And we also, I believe there was an article in our most recent newsletter that kind of pairs with this. So if you're looking for something, in a different format, you can look at our most recent newsletter as well. There's a question that says, to clarify, for contracts, it should be the name on the certificate of formation and not the CCRs. Hopefully those match. Ideally, the defined term for the association in your declaration or your CCRs matches the certificate of formation. But at the end of the day, the name that is registered with the Secretary of State through your certificate of formation or your articles of incorporation, that's the entity that actually exists. So you would want that's kind of the name you want to defer to. And if for some reason the name of the association is listed in your CCRs doesn't match the name on your certificate formation, you might want to reach out to your association's attorney just to make sure that's not something that needs to be cleaned up for other purposes. Many contractors.
Actually,
I'm sorry, go ahead.
I was gonna say, let's tackle that last one together. So is there a way to control, okay, at January of every year, if I don't have a new certificate of insurance? So I think this question was twofold. One, for a renewal contract versus a renewal certificate of insurance. So if your contract governs the additional insured and everything it should already, and it's an open-ended MSA with that contractor, I would think that that you would want to say, okay, every January you're not getting paid until you give me your new certificate of insurance. So that's the insurance side of that question, and then I'll let you address the renewal of the contract.
Yeah, so renewal is really going to be governed by the existing contract, unless unless by renewal you mean you're signing an entirely new agreement. So a lot of renewal provisions will basically say, this contract has an initial term of a year, but if neither party gives notice of an intent not to renew before a certain, usually 30 or 90 days before the term ends, that it's going to automatically renew for successive 1-year periods. So in that case, if you're wanting to change the terms of the contract, you need to kind of keep an eye on that notice period, because what you might need to do is say, we're not renewing, we want to renegotiate this agreement. So it's really going to be governed by the specific details. So you'd want to have an attorney look at the existing agreement and kind of see how that would be handled. But without, otherwise, we run into the risk of it just auto renewing under the exact same terms that already exist. Let's see.
The other piece I'll add to that really quick, as far as additional insured goes, is if you're using an outdated contract to where you only require general liability, but you get an updated renewal certificate, and now it includes the vendor contractors purchasing excess liability. The majority of additional insured endorsements out there are going to limit coverage to that required by the contract. So we would always recommend making sure that the limits of insurance in the contract mirror what's shown at a certificate of insurance at an absolute minimum, so that you're maximizing the amount of risk transfer that's potentially available. The last thing you want is a claim to occur. You only required $1 million for GL when they had $2 million excess, and now you're leaving $2 million off the table. So be sure to make sure that the limits are mirroring what's shown on the certificate, an absolute minimum in the contract as well.
Yeah, it all kind of talks together, and that's why we're saying, you definitely want to involve both the attorney as well as your insurance professionals, because at the end of the day, they're going to be more qualified to talk about the policies and things like that. And so it's really, it's important for both of those groups to work together. Kyle, there's a question about proof for CE credits. Oh, looks like you already responded to that, so never mind. What sort of third-party claims could be made against a pool cleaning company that only cleans the pool and maintains the pumps and tests pH? Well, I'll start by saying that anybody can sue anybody for anything. It's a matter of whether or not the claim sticks. I suppose a pool cleaning company is less likely to be have liability for something like if somebody dives into the pool and gets a head injury. But we are seeing, I think this was mentioned when Kevin was discussing the environmental coverage that's become more popular, things like Legionnaire's disease and things like that could be, potentially tied to proper cleaning and pH of the pool. So there are claims that could involve companies whose services are sort of limited to cleaning and maintenance of pH and things like that. It might not be the same extent or the same type of claims that would be brought against somebody who provides lifeguard services, but it's not outside of the realm of possibility.
And I would add to that, workers' compensation is a big one. We did have a scenario where an employer didn't provide workers' compensation and an electrocution happened. And so those types of scenarios can potentially expose the association as well.
Yes. Yeah. Workers' comp, I think, is maybe one that a lot of people don't put as much emphasis on. It's very easy to focus on these liability, these general liability policies and things like that. But workers' comp is very important for vendors who don't carry workers' comp insurance, they're in the unfortunate position of not being able to put on certain affirmative defenses at trial. So it can have like a pretty significant impact on the defense of a claim. What would be the best practice for requests from PTA, PTO organizations wanting to host pool parties at HOA facilities? So sort of renting out the pool for parties and things like that is sort of a whole other beast. Normally you would still want some sort of written agreement, containing rules and saying things like, no alcohol, no glass, no diving. It might be that depending on the pool and the association that you want to require a lifeguard to be present. Maybe you want to require security. And then you want, it would be ideal to require some form of insurance. Now, a homeowner or even a smaller organization that's leasing out the pool might not by default carry the insurance that you would expect from a pool contractor, but that is something you sort of want to tailor an agreement for. You want to work with your attorney to tailor basically a facility use agreement that would cover all of these issues.
Yeah, I would say it's no different than if you were hosting a meeting at a school where they're asking you to sign a contract and provide a certificate and listing them as an additional insured. You want the complete opposite in your favor at the association level if you're going to allow a third party to use your premises.
Do you know if pool and landscaper contractors are aware of this law and making changes accordingly? Just wondering if they are somehow made aware of these laws by state entities, et cetera. So I'm not sure what law that's referring to. If it's the bid solicitation law, I would assume that most contractors are not going to be aware of that. It's very HOA specific. I mean, it's possible that they will, but I doubt it's something they'd be keeping an eye on. A lot of the things that were discussed today, though, are not like legally required. So and HOA is not like violating any sort of statute if it enters into an agreement like this, and maybe it doesn't have as much insurance as we prefer to see. So it's not a violation of the law, but it is, it does create issues. I would say pool contractors are probably aware. I mean, I would think they're at least used to seeing what associations are asking for and expecting in terms of coverage. They're usually involved in the claims that we're concerned about, so they would be aware of things like trends with respect to like claims and payouts. So, they're kind of viewing it from a different perspective than we are. They're thinking about, protecting their interests. So I would assume that they are aware of a lot of these issues, but maybe their sort of approach to it is going to be different than an association's would be.
Yeah, and so they switched it to say, sorry, requirements, not law.
Okay.
I think that any contract you negotiate is going to start out in their favor. I'll give an example. So not just pool contractors. We had a vendor of an association that put indemnification provisions in favor of the association up to a cap of $2,500. So we're being nice, but we're capping it at $2,500, even though we have $50 million in liability insurance. And so that can be troublesome when you're working a claim for sure. So I just keep that in mind that the sophisticated associations and association attorneys are willing and able to help and get the contracts in your favor. You're hiring a vendor to do a service for you. And if they already have these coverages, they can give them. We just have to know to ask for them. And so that's why we encourage using professionals to make sure they're watching what we see regularly. It goes both ways. We want the world as an association, and the vendor wants to limit that world, which makes sense, but you can come to a good middle ground.
Yeah, there's usually, you can expect in sort of any sort of contract negotiation that whatever side presents the first draft is going to be very heavily favoring their client or themselves if they're drafting it themselves. And oftentimes what you end up with is some sort of middle ground, because it might be the vendor proposes an agreement. It comes to us, we kind of, pull a 180 and they have it very association friendly. And then it kind of goes back and forth until you end up with something where, both sides would probably like to see something a little different, but it's enough that they can live with it, basically. It usually ends up somewhere in the middle.
So final question is, if you have bids for contracts for pools and one vendor has 10 million of insurance, the other two don't have that high of limits. I'm kind of paraphrasing. Is it better to go with the one with the better, higher coverage? It depends, and it's really one-off that those need to be addressed, because of that 10 million is split up among 3,000 customers and it's not per project. Then we might be better off with somebody that's got 40 clients and $1 million of coverage. So it's too specific to answer without knowing more of the facts, but hope that helps while not helping.
Well, and also it might be a situation where a vendor carries more insurance, but all the referrals that you've talked to other associations about, they're saying, well, they don't do a very good job, or, we weren't happy with the service they provided. At the end of the day, there needs to be some sort of compromise between, having enough insurance to where you're not putting yourself in a bad position, but also making sure that you're, getting the level of service that you want from your vendor. So there's just a lot of factors to be considered when you're making that decision. I'm gonna let y'all take this last question. Outlook for insurance industry.
You're breaking up.
It's so specific. It depends, really. I mean, single family associations are relatively flat to staying under inflation if they haven't had claims. If there's been severity of claims, you're seeing people get dropped. Condo and townhome, that's a whole nother story. The property insurance market has been really tough. The service industry, it really just depends on claims and size. So it's a tough one to take, but if you have more specifics on industries or anything like that, we can go offline, and my contact information is on our website.
All right. Well, we're, coming up on the hour mark, and I don't see any additional questions, but, as Tim mentioned, his contact information is on BCH's website. You can certainly reach out to anybody at our firm if you have any questions. For specific questions about maybe contracts your association has already entered into or is looking to enter into, we just really, really encourage you to reach out to whoever your association's attorney may be, and to also make sure that the broker kind of gets looped in on that process to make sure that these sort of issues are addressed at the front end. So, thanks to both of y'all for presenting with me today, and thanks to everybody who joined. Hopefully this answered a lot of your questions, or at least kind of gave you the information you need to know, when to get somebody involved.
Certificate of insurance.
Thanks, Ashley. Great job.
Piece of paper. Contract is key. Thank you all. Have a great day.
Thanks.
All right. Y'all have a great day. Thanks.